What's up, guys? Brian Felfel, Law Group PLLC with your Florida Law Weekly case update. It's back to school week, so that's good for all of you parents out there. Hope everybody had a great summer. It still feels like summer outside because it's so hot, but at least the kids are going back to school. We got a bunch of cases this week. First case is out of the 4th DCA, Bergman versus Bergman, has to do with interest on alimony and child support arrears. Don't forget to ask for interest on it. Trial court erred in this one because it said that the former wife failed to meet her burden to prove the interest because she failed to put on evidence of the interest on the arrearages. But it's sort of like a catch-22 because she couldn't have known what the arrearages are until the trial court actually determined what the arrearages amount was. So the appellate court reversed that and says, hey, you get to claim interest because you frankly wouldn't have known what the interest would be anyway if you hadn't gotten the final judgment. So first get the judgment on the arrearages, then the court can compute the interest. Also reversed was a failure to award her attorney's fees because allegedly she didn't plead specifically for prevailing party attorney's fees under the MSA. Now the appellate court said, well, you don't really have to specifically plead prevailing party attorney's fees where the other side doesn't object. So I think that was the key here, is that the other side didn't specifically object to the failure to plead at the trial. And so it was too late to say, oh, you didn't specifically plead for a prevailing party under the MSA. Next case is McPherson versus Samuel. It's again out of the 4th DCA. This is an injunction case, but it actually has to do with appeals and whether you can get costs, not fees, but costs as a prevailing party on an appeal. And I've done prevailing party litigation earlier in my career, and I know that you have to prevail on the significant issues in the case. Now, the question here was, what was the significant issue in the appeal? In this case, it had to do with an appeal where the respondent to the injunction was not given due process. So the respondent appealed because she was out of the country, and the court went forward with the hearing even though it knew that she was out of the country. The appellate court reversed, said lack of due process, but the temporary injunction still remained. So the petitioner for the injunction was saying, well, they didn't really prevail on the significant issues in the case because all she got was kind of a do-over of the hearing, and the temporary injunction remained. But the appellate court said no, she prevailed on the specific issue that she appealed for, which was the due process issue. So she was able to get her taxable costs under 9.400, I believe, which of course is different than fees. Costs is just, the cost for the filing fee and probably things like that, maybe preparing the record. Next case is Aabbott versus Kligman. This is out of the 3rd DCA. This has to do with supervised visitation where apparently there's something going on with the father, but he was awarded supervised overnights with the child, 2 supervised overnights with the child, and I believe that was probably not good enough for the mom. There was probably some sort of safety issue, I'm not sure, but she appealed and she had presented expert testimony, which apparently was unrebutted, or maybe the other side didn't have an expert. So she was arguing, well, I had an expert testify that the time sharing for 2 overnights was not in the child's best interest. And the appellate court said, well, you know what? The trial court is free to disregard your expert, essentially. It can not find your expert credible or not find your expert persuasive, even though the other side may not have rebuttal testimony. The trial court's within its purview to say, I'm not really finding your expert credible. So just the fact that one side has an expert doesn't necessarily mean that you're going to win. Next case is Gorla versus Vig. This is again out of the 3rd DCA. This is another. This has to do with whether it's okay for the court to order that a spouse who has a controlled substance restriction on his time sharing, like one of those things where you blow into the meter to make sure you're not drinking alcohol under the influence of drugs or alcohol, whether you can hold that person solely responsible for the costs of one of those machines. And the answer is no. If it's a condition of the person's time sharing that they have to use this machine, the costs of that are really supposed to be included in child support, and they're supposed to be split, divided among the parties. So the mom had to at least contribute something towards that. Next case is Wallace versus Wallace. This one is like, oh my gosh, what a big do-over. Like, seemed like the trial court kind of just got everything wrong, no offense to them, but this is a huge a huge mess up, let's say. So the court erred first in verbatim adopting the father's proposed time-sharing schedule, and by not even mentioning the fact that the father had a domestic violence injunction against the wife, I believe, for battering the wife in front of the kids. Not even mentioned, no mention of that in the final judgment, in the parenting plan. So the court reversed because, for among other things, parental responsibility, shared parental responsibility, the court has to consider whether there's been domestic violence. That's in the statute. And, it's one of the time-sharing factors as well. So the court had to at least consider that. So that got reversed. The alimony award got reversed too because the husband was voluntarily unemployed. He was the one seeking alimony, the husband, and he was an accountant, but he was temporarily unemployed. And he was saying, "Well, I'm unemployed because I have this domestic violence injunction." And I think there was a criminal conviction of domestic battery on the wife, in addition to that domestic violence injunction. And so he was saying, "Well, I'm not able to get a job." But there was evidence that he was able to get a job regardless of that. And the main thing is also the alimony award exceeded his need. So even on his financial affidavits, even with his low income, he still really didn't have a real need for alimony. And the court basically based its alimony determination on the disparity in income of the parties, basically, kind of trying to equalize the parties. But that's not what the court's supposed to do. It's supposed to be need and ability to pay. So if former husband doesn't have an actual need, then, you can't get alimony. Then there's a bunch of other issues where the trial court erred in failing to identify and value certain assets, and specifically failing to properly value the parties' 401ks. So the 401ks, so for example, for the wife, the 401k increased in value post-divorce filing, due to the actual efforts of the wife, due to her contributing money post-filing. And the court said that it was error to not exclude her post-filing contributions. But at the same time, the court should have valued the 401k at the date of the trial, because the passive appreciation should have been considered as a marital asset, but the active contributions are not. And then there's also some issues with the loans, not including loans to the 401ks that were taken out, and failing to consider the husband's depletion of his 401k account. Potential depletion apparently went completely down. He said he spent the money on living expenses, but the court didn't really consider that. Failed to do an analysis of that, so that was another error. And there was a bunch of other errors in valuing the marital home. The court said that it could value the marital home as of the date of the trial, but it had to include the mortgage, I believe, as of the date of filing. So what the trial court did was it just awarded a net amount. It didn't really give a value. So you have to identify, value, and distribute all assets and liabilities. So you have to identify the value of the house on a specific date. The value can vary. The cutoff date for determining whether an asset is marital or non-marital is the date of filing, usually. But the court has discretion to value it at certain dates. But they still have to actually do that. They can't just do a net amount. Last case is Anderson versus the school board. This is just sort of like one of those, oh my gosh, I can't believe it. Another one of those cases where it's not a family case, but I thought it was interesting because it was a wrongful death. A poor kid, a 4-year-old kid who had special needs, he choked at school and eventually he died. And so the parents sued, the mom sued the school board. She got a lawyer from Louisiana to initially kind of try to negotiate a pre-suit settlement, but they didn't specifically comply with the pre-suit notice requirements. Even though he was going back and forth with the counsel for the school board trying to reach a settlement, he didn't specifically comply with the pre-suit notice requirements. And so eventually they teamed up with local Florida counsel and they filed a lawsuit, but then they ended up losing on summary judgment. Got a final summary judgment against them because they did not comply, among other reasons, because they did not comply with that pre-suit notice. So gotta really be careful with that. Pre-suit notice requirements, things like that, you gotta do it. Otherwise, you might get caught and might not be able to get a judgment. That could be a potential malpractice, who knows. All right, guys, that's it for this week. I hope everybody enjoyed it. Take care.